we've inadvertently found millions of dollars that we would not have found. We've also had clients pass away, and the only place they had the keys to their crypto wallet was in their head, and now their head is inaccessible. Comply with the rules of your social media account, where you've stored your photos, where you've stored your emails, your crypto wallet, and all those kind of things. Hi, this is Rick Durfee. Today we're going to talk about digital asset protection. Digital assets, how we integrate them into an estate plan, and how we protect them. This is an emerging area of the law. The law is changing as we speak, partly because digital assets are changing as we speak. They're not the same today as they were just a very short time ago, and guaranteed they're going to be different in the future. So there's some very specific things we need to do. Number one is be aware of them. And it is crucial that your legal documents, if you have a trust, if you have a will, if you have other documents like that, that they address what will happen with the digital assets and that they are very specific. It is common, for example, for planners who are up on this to have some kind of a conveyance, an assignment or a transfer of some kind, conveying digital assets to a trust, for example, or to a legal entity. Even when you do that, you still have to work with the digital asset custodian or provider to comply with their in-house rules to follow whatever protocols they have in place to accommodate the transition or a transfer of power or ownership. So there's a couple of steps that you want to do. Comply with the rules of your social media account, where you've stored your photos, where you've stored your emails, your crypto wallet, and all those kind of things. So when you're going to do this, we recommend, for starters, that you make an inventory. Detail out in writing all of your digital assets, and then record in writing, I know this freaks some people out, the passwords and the access, the security protocols you have to go through, whether you have two-layer authentication or other security protocols, and those also are changing and evolving as we speak. So whatever the security protocols are, make sure you've documented that. And then that document, and sometimes this can be an online vault of some kind, and there's a number of providers that do that. Although, let's just be honest, the very best and most powerful of those online resources have been breached in the past. So the probability of the strongest and best being breached in the future is more than zero. So I like to suggest to clients that you put this on paper. Paper just works. But then you need to secure that paper. It needs to be in a place where the bad guys that want to rip you off can't find it and use it to their advantage and to your detriment. So one of the things we've had a lot of our clients do, they will create a sealed envelope with all that information in it. They give it to their lawyer, protected by attorney-client privilege. The lawyer takes custody of that and puts it in the client file. In our office, we have a safe file, fireproof safes where we keep these kind of things, with instructions of when do I release it. This is to be opened only in the event of my death. This is to be released only in the event of my incapacity, or whatever the instructions you want. And then if that event occurs, you pass away, you become incapacitated, the lawyer's going to pull the file and go, oh, hey, we have an envelope here. Now, I've had those envelopes. Client passes away, we zip it open, and we read it, and the client says, hey, I've buried a can of gold coins in my backyard, 20 paces from the old oak tree. So we've been able to find huge assets as a result of having those confidential records in our safe file. We've also had clients pass away, and the only place they had the keys to their crypto wallet was in their head, and now their head is inaccessible. So make sure that you don't lose assets by failing to leave breadcrumbs so that your survivors can come along after you and find them. And this is true, by the way, of also pay-on-death beneficiary accounts or transfer-on-death beneficiary accounts. Financial institutions are under no obligation to hunt down those beneficiaries and tell them about the assets. If they don't know about them, if there's not a clue, hey, go looking for this, they won't. We've inadvertently found millions of dollars that we would not have found, but for some fortuitous accident that we stumbled upon this account. Oh, there's a pay-on-death beneficiary in this account, and we go and find it and discover here's all this money. So make sure, again, that you leave breadcrumbs. So a detailed inventory, include the passwords and the security protocols that you need to get through that, put it in a secure place, and then leave breadcrumbs so the appropriate people can ultimately find it and the inappropriate people can't. So this is a crucial part of estate planning and asset protection. If you're leaving this out, you're not doing a full job. If your advisor is, decades behind the technology curve and not talking to you about this. They're leaving stuff out. So look at your estate plan. If you're several years old with your planning documents, odds are you didn't do this. That might be something that you consult with your attorney and your advisory group and make sure that you have appropriately identified the mechanism and the means by which your successors can gain access to these digital assets. We love to help people with this stuff, and we understand you may have the best attorneys and advisors in the world, and more power to you. Go to them and work with them. We are taking on new clients. If we can help you, we would love to do so. We do have a waiting list. Get in the queue. We'll get to you as fast as we can. If you have questions that we haven't addressed, let us know. We'll answer your questions. Click the links below. Look for the phone numbers and the emails, and you can find us.